happens in the post office is really closed to me. So all I can do really is give anecdotal evidence of what appears to be happening from where I'm standing. And I've really identified, I think, the matters which have been of concern over the last year. That is the speed at which documentation is produced, the requirement of claimants and their representatives. They ask too many questions to require them to particularise their claim in too much detail, which then you may have to do in court proceedings, but not necessarily in these assessment proceedings. And thirdly, some delays, I think, during the governance procedure. So when something goes off to them for decision, it just seems to take quite a long time to get through the post office governance procedure for a decision to come back. I mean, often that decision is positive, but I think there is scope for saving time there too.
And yeah, earlier this afternoon we heard from sub-postmasters and legal representatives about how their schemes have been complicated, and for reasons including the involvement of multi-scheme administrators and the burden of work on claimants who might have initially lacked legal representation from the beginning. Based on your own legal experience and wider knowledge of the schemes, do you share this concern?
It's certainly a scheme, and it's certainly a concern, and it may be more of a concern in the other schemes where there are a lot more claimants. In the scheme in which I'm involved, and this is a generalisation which is not universally true, but all of the claimants have been prosecuted, convicted, and then had their convictions overturned by the court. So one can possibly expect quite a high general level of trauma for these particular postmasters compared with other postmasters in other schemes. And that's not saying that other postmasters in other schemes have not had very considerable trauma because they've been sued and been made bankrupt and all sorts of other terrible things. But there is a high level, I think, of trauma amongst these particular claimants. And I think in working out the best way of dealing with the claims, one has to bear that in mind at all points. So I'm very happy to put pressure on the post office to return with a response to an offer within 40 days, because there's usually no good reason why they shouldn't do that as a general rule. But with claimants, it's far more difficult, I think.
Yeah.
Chair, you mentioned in your October summary reports how you saw that as less complex cases were settled, you thought you were going to be left with obviously the more complex cases, and you mentioned about future loss claims earlier. Do you think that's something that will only be specific to the overturned convictions, or do you think it will actually affect any other schemes? And if so, are we going to see a build-up and a backlog of these higher value, more complex cases?
I think the answer to your question is yes. I think that there's no reason to suppose, in respect of the new scheme, OC2 scheme, that the claimants will probably have a similar profile and similar issues will arise. So one can expect within that cohort to have big future loss claims. I mean, for various reasons, one might expect a bigger proportion of those claimants to accept the 600,000, but that may or may not turn out to be the case. But the issues, I think, will generally be the same. And in respect of the other schemes, about which I know less about the claimant cohort, I'm sure that as a matter of logic, they too will have claimants with, for example, future loss claims, and they will be left as a rump of their particular cohorts. And that's why for the hearing, which I hope is going to be early next year, of the claims within the OC scheme, which the panel, I hope, will look at future loss, I really want to get as much value out of that hearing as possible, and for as many categories of people and representatives to buy into that hearing. So what I'd propose to do is certainly to ask representatives with claimants in the other schemes whether they want to make submissions, whether there's anything we can, whether there are any aspects of these issues which are peculiar to their scheme, so that we get the most out of these hearings, so that the guidance is as helpful as it can be.
Thank you,
Chair. Do you think anything should change in the current design of any of the schemes to ensure faster and fairer redress?
I can't really speak of the other schemes because I don't know enough about the GLO scheme and the HSS scheme. In terms of the OC scheme, and as I say, similar issues are likely to occur in the OC2 scheme, I think that I have to be very sensitive to what may happen in the future, and as I say, we've ruled out the possibility of we've ruled out the advantages of a facilitator in our scheme because we have a small number of cases and we're going to be left with a smaller number of challenging cases. But I certainly don't rule out things like early neutral evaluation, in particular claims, if that's a way that might break through in that claim and result in a settlement. I think, generally speaking, and I've done a number of things in the OC scheme to try and moderate this. For obvious reasons, where the administrator of the scheme is the post office as opposed to the DBT, there are clearly trust issues with the claimants and sometimes the claimants' representatives, certainly with a proportion of the claimants. So I think it's very important that we, or certainly I, within the OC scheme, maintain both independence and confidence in all of the parties, but particularly not just the claimants' representatives, but the claimants. The claimants have to believe that they are going to get fair compensation through the system, including the assessment.
Thank you very much. Just the last question that I have is just an observation, really. I mean, you said at the beginning that your role appears to be having a positive influence on the way that the system as a whole is working. And I think one of the things that you're able to encourage is just a bringing of sides together to try and make progress in settling pecuniary losses. And that's not something that Sir Ross Cranston can do in the GLO scheme. So I just wondered if you're thinking about the system as a whole, even without knowing the complete detail of them, it does feel like the role that you play could be a role that is usefully replicated in other schemes in just trying to get some adjudication at an earlier stage in the process about some of the thornier problems like pecuniary loss.
Possibly that's right. I mean, the only powers I have under the OC scheme are soft power. I mean, really soft powers. I can't actually order anybody to do anything. But I mean, for example, and probably the best example is the 450,000 interim payment, which I recommended because I thought if as part of the scheme, claimants are offered 600,000 in full and final settlement, 163,000 by way of interim payment at the beginning of when they make their claim, was really an inappropriately small proportion of that figure when they come to make a fully particularised claim. So I recommended 450,000 as an interim payment at that stage, and that was accepted. The soft power I had being, I think, supported by the advisory committee helpfully. In terms of bringing parties together, I have meetings with the parties' representatives on a regular basis. I've got one next week. They can put anything they want onto the agenda, and we just look for ways in which progress may be made, either as a cohort or in individual cases, although in that the individual cases are confidential in that particular forum, but sometimes we can identify, or I can identify, cases which I think would be helped by having a meeting between me and, on the one hand, and either both parties, or sometimes just the claimants, with the Post Office's knowledge and acquiescence, just to see whether there's, what do the claimants think are holding up their particular individual claims, and sometimes we can do something about that. And I've got a meeting with one of the claimant representatives again later this month to do exactly that.
Seems to me we might need a bit more of that. Gary, thank you very much indeed for your evidence. That concludes this panel. It is only left for me to provide the breaking news to members of the committee that the Prime Minister has now responded to the letter from Sir Alan Bates. So we look forward to receiving that and considering it. That concludes this session. Order, order.